Cedar Falls, Iowa, where his parents still live, and he resides there now. Again, he graduated from Hillsdale College, and also after Hillsdale, taught for a couple of years in a private charterish type of school in the Detroit area, teaching classics in the Detroit area. Interesting concept. He then came back to Iowa, where he graduated from the University of Iowa Law School. He went and clerked for a year with Justice Waterman at the Iowa Supreme Court. He is now with the Redfern, Mason, Larson, and Moore, right? Did I get them all? Okay. Practice in Cedar Falls. A year ago, he married Mary Arch, and on their first anniversary, Lord willing, they will be giving Carol and me our 8th grandchild. Right? No, we love Luke, and a godly young man. He's going to talk to you now for this hour about some of the legal challenges that we face.
Thanks. Yes. Well, he is my father-in-law, so I won't pick on him with any questions, but the rest of you should be ready for questions at will from me. That's what I had to go through in law school, so now that I'm the one up here talking in front of you all, I'm going to put you through the same thing. So be on your toes. All right, so we're going to talk a little bit about some legal problems that are confronting seniors and some things that are getting to them that seniors are facing at the end of their lives. One of those things that we need to talk about is estate planning, and one of those things we need to talk about is planning for incapacity. Those are two areas of the law that I can tell you, at least through my experience, the law is not necessarily broken or unjust. There are many other areas of the law that I can tell you that the law is absolutely broken, the legal system is broken, and it is unjust. Fortunately, we as Christians, we can measure the justice or injustice of a law or a decision based on the extent to which it comports with God's law. The things we're going to talk about today, except for a little bit at the very end, I hope we have some time to talk about some of the developments in the state, in our legislature. Everything is sound. A lot of what we're going to be talking about today is property law, property rights that you have in assets that you own, and the law for the most part is just. It recognizes individual ownership. Individual ownership, of course, is roundabout way rooted in the idea that God has given us material blessings. They belong to us, and he has entrusted us with the stewardship of those material blessings. It's up to us to do with those things what we want. You hear in the news about squatters taking over people's houses. That's the exception to the rule. For the most part, if you have a house, that's an asset that you can do with what you want. And the law will recognize that. So when we're talking about estate planning, we're talking about rules that are just, and we can apply them, and we know that they will produce just results. So we don't have to second guess the decisions of judges when we're talking about a probate court, when we're talking about laws that are passed concerning the probate code. We don't have to worry as much about looking at that lens of, is this something that's just or not? So, did I hit that? All right. So, my perspective, as my father-in-law mentioned, I am a practicing attorney. I do not practice in the area of wills and trusts and estate planning. What I do is litigation. The practice of law and private practice breaks down into litigation and then transactional work. Preparing wills and trusts, preparing people's estates, that's the transactional side of things. I'm on the litigation side of things. But when things go wrong on the transactional side, when you have a problem with a will, when you have a will contest, when you have something that goes wrong with a trust, that goes into litigation. So I still have experience with these things, just when things haven't worked the way that they should. So I can identify when there's something that might go wrong and how we can address that. So I hope to share along the way today some sometimes humorous illustrations of how these things come to my area of the law, fighting things out in court, and how we can hopefully avoid those things for you. My background, I also spent some time on the legislative side of things. In addition to the judiciary, I interned for Senator Grassley. So I've spent some time in Washington. I know a little bit of how laws get made. And when you talk about how laws get made and then how laws get applied in the courts, that's what affects you and your interests when it comes time to probate a will, that sort of thing. So I have a little bit of experience all the way through the entire lawmaking process. So with my experience and what we want to talk about today, I want to give you some things to consider, some things that you need to be thinking about, some questions you need to answer for yourselves in order to make sure that your estate plan is shipshape and ready to go. I am not giving you legal advice today. You're talking to an attorney, of course, there's going to be a disclaimer, there's going to be fine print. I am not telling you what you should or should not do. I'm giving you general guidelines, some things that will be good for you to think about. You should not go home and draw up a document yourself based on what you heard me talk about today. That would not be a good idea, and I'm not telling you to do that. I'm not your attorney. If an attorney took on a client for every person who is sitting in a chair where you are today, the lawyer would never get any other work done. So you're not my clients, I'm not your attorney. We can talk about that some other time. This is strictly informational, not necessarily legal advice. Okay, so big topics we want to cover today. We want to talk about estate planning. We want to talk about what to do with assets. We want to talk about what is going to happen when you are no longer around to tell us what should happen. And part of that also includes advanced directives and talking about planning for incapacity. Incapacity, not something we want to think about or talk about much, but it's something we all need to be thinking about. I think the statistic is that somebody who is 25 years old today has a 58% chance of being incapacitated for 3 months or more at some point during their life. So that's something that anybody at any stage of life needs to be thinking about right now. I also want to get into some nuts and bolts things as simple as selling a house. There are a lot of problems that can come back to bite seniors with doing something as simple as selling a house. And then at the very end, I do want to cover some opportunities that you guys have to shape the law, given that your demographic actually has an outsized chunk of the voting population. So we'll get to that at the end. So we can start with estate planning. Now, what is an estate? An estate is a legal entity that comes into existence when somebody has passed away. Right now, you might own a car, and the car is titled in your name. But after you die, you're not around to do something with the car. So the car, if it's titled in your name, goes on to your estate, goes into your estate after you pass away. So the estate steps in and then takes ownership, essentially, of all of your things when you're no longer around to own your things. When you're talking about arranging your estate, you would often need to include multiple professionals, not just an attorney to draw up a document, such as a will or a trust. You'd want to talk to somebody like Bob, who can give you some financial advice. You'd want to talk to people who can help you navigate some of the very fine, some of the very nuanced things that you have to worry about when you're dealing with money and you're dealing with large assets, such as tax law and other things. The big thing we want to consider, and the big thing we want to tackle when we're building an estate, big picture for the client, somebody who's going to be planning an estate, is to realize the client's objectives. And this is something that no professional can decide for any client. When an attorney takes on representation of a client, the attorney is ethically obligated to recognize the client's big picture wishes. The client gets to drive the boat and decide where the boat is going to go. The attorney is there to decide what route we're going to take the boat on. So the client has to set the parameters, has to set the ultimate goal, and the attorney can decide how best to realize that goal. So a lot of what you need to do before you even talk to an attorney or a financial professional to plan an estate is you need to have some ideas in mind about what you want to have happen. Who do you want to get your house? Who do you want to have get your bank account? Is it the entire account? Is it just a portion of the account? What happens to your IRA? These are all things that you need to consider ahead of time. So you need to plan that, obviously, before you can do anything about it. And what the the answers to those questions are the objectives that you want to accomplish. Do you want to provide for children? Do you want to provide for education for grandchildren? It's all up to you, and you get to call the shots. So when you plan your estate, you're telling us what you want to have happen after you die. Now, you need to do that because you're not going to be around to tell us what to do with your stuff, because we can't talk to you anymore. And what Bob mentioned was, it's not an if question, it's a question of when this happens. I would qualify that and I would say, unless your name is Enoch or Elijah, and as long as the Lord tarries, well, although even if that happened, well, you still have to decide, even if you are Enoch or Elijah, what's going to happen, because they're not around anymore. So regardless, it's a when question. You need to tell us what you want to have happen. You don't want to make us guess what's going to happen. There can be some funny outcomes if we have to guess what you wanted to have happen. Let's say there's a guy named Tom, and he has 2 kids. Call them Alan and Barb. And Tom is going to leave behind a modest estate. It's amazing when you do these illustrations how the numbers always end up being nice round numbers. Tom's going to leave behind an estate of $100,000. Okay? And Tom provides in his will that it's supposed to go 50-50 to Alan and Barb. So easy enough, right? Alan's going to get 50, and Barb's going to get 50. Well, what if Alan decides he wants to start a business? And Alan comes to Tom and he says, hey, Dad, I want to start this business. Here's what I want to do. Can you give me $20,000 to get my business off the ground? And Tom says, boy, Alan, I love your go-get-em attitude. I really believe in what you're doing here. I'm going to give you the $20,000. If Tom gives Alan $20,000, does Tom still have $100,000 left to give to his kids? No, he doesn't. Tom doesn't have $100,000. He has $80,000. Well, what does that mean for Alan and Barb? Does that mean that they get $40,000 each? Somebody shaking your head, why not? Oh, wait. Yeah? What? Uh-huh.
If he doesn't account for the $20,000 and change the will to account for the $20,000, it will be $40,000.
Okay, so
Change the will for that to happen.
so did Barb hire you as her attorney? And did Alan hire you as his attorney? So this is exactly what happens when this situation comes up. We can either say, well, Tom already gave the $20,000 to Alan. There's $80,000 left in the estate. The will says it's going to be split 50-50, so 40 and 40, right? No, Barb's not going to like that. Barb is not going to like that because Alan already got $20,000 of his initial 50. So Barb's going to say that Alan should get 30 in addition to the 20 that he already got, and Barb is still going to get 50. Oop. Okay? So which one is right? Right. Or what if there's no will? What if Tom dies without a will? The probate code, by the way, the probate code in Iowa is 145 pages long. We can get more into that in a minute. But the probate code says that Alan and Barb are supposed to split everything that Tom had left equally. Is that what Tom wanted? So this is kind of the prodigal son problem, where Alan is effectively saying, hey, give me my inheritance early. And there are fancy terms for this. We can call it a lifetime gift, or we can call it an advance on Tom's testamentary share or on Alan's testamentary share from Tom. Bottom line is, you need to tell us which one of these is supposed to happen, whether the kids are supposed to split it 40-40, or whether Alan and Barb are supposed to split it 30-50. You get to control that. There's another fun example from Iowa. This happened in Iowa. A lot of funny stuff happens in Iowa. I hope to get through all these illustrations. In Iowa, there was a woman. She had a rather large house. She was a big antiquer, and she had amassed many fine pieces in her collection. She had them sitting around her house, and she knew that she was in the final years of her life, and she wanted to plan. She wanted to avoid the Allen and Barb situation, and her solution to avoiding the Allen and Barb situation was to go around and put sticky notes with people's names on all the antiques. So she went over to the grandfather clock and she wrote out Bobby, and she slapped that on the grandfather clock. And then she went over to the chest of drawers and she wrote down Susie, and she put that on the chest of drawers. Well, do you know what happens to sticky notes after they stay on things a while? They're going to fall off. So when there was a nice oil painting higher up on the wall and there was a cheaper end table underneath it, and both the sticky notes from the oil painting and the end table had both fallen off onto the ground, one said Bobby, one said Susie, do you know what Bobby and Susie did? They're both going to claim the nice painting, right? So we don't want to avoid, we want to avoid that situation as well. So the way you do that is you make sure that everything is in order, and everything is good to go ahead of time before it's too late. The moral of the story is going to be act sooner rather than later. That's going to be something we come back to in a minute. Yeah?
We had that very thing in our family. I don't know in the state of Indiana what the rules were, but my sister had borrowed money from my parents, and my dad died at 1960. But my brother and I had already talked to my sister and said, I don't know for sure how you work this all with Dad, but we need to make sure that this is equitably. And she was quite, Gina, she was quite aware of the situation, but it prevented us from having a sticky thing by working that out.
Mm-hmm.
So what we thought as a family was equitable, regardless of what the state of Indiana would have done.
Right, and that's the big perk of doing your own planning rather than relying on the state of Indiana or the state of Iowa, is you can decide what you want to have happen. And you'd be amazed, even if you have a good plan in place, you'd be amazed how grabby and how selfish people get as soon as hundreds of thousands and millions of dollars start flying around. I'm working on a probate of an estate right now. It's a relatively small estate. There's a house, there's a small bank account, there's some John Deere stock. That's what we're working with. And the daughter and the son cannot get along just because there's $75,000 on the line. It's kind of sad. So you want to have your wishes known. You want to have this all in place before the family can fight and before they can take issue with anything that's happened. Maybe. If you ask a lawyer a question, the answer is almost always going to be maybe. The question would be, was there a witness there to see her write the sticky note and then put on the object? Right, it would have to be, and okay, so that's a big thing we get into wills. Hold that thought about the formal requirements for wills. So. Hold that thought. Hold that thought. Yeah. Another thing to consider when you're planning your estate, not every asset that you own is going to end up in your estate. If you own a house, let's say you're married, you own a house, joint tenants with right of survivorship is the fancy word for it, but you own a house jointly with your spouse and you die, your spouse is going to end up with the house. The house doesn't go into your estate. But something else that might is, say, a life insurance policy. If the life insurance policy pays out and the named beneficiary is no longer alive, well, that has to go into your estate. So you need to be cognizant of how you have your assets titled when you go to plan your estate as well. Yeah, question? So, okay, so she had made a bunch of lifetime gifts. Right, so that is one option that you can do. Not everybody is going to like that, though, and I'll give you an illustration of why. Let's say today, on April 13th, 24, you go out and you're going to buy 10 shares of ABC Corporation stock. Now, ABC Corporation, I'm sure, is thrilled with your investment in their company. And I'm going to tell you that today, ABC Corporation stock is trading for $10 a share. Okay? So how much money did you spend? $100, okay. So today you spend $100 on stock in ABC Corporation. Now, let's fast forward 1 year, April 13th of 2025. You still own your ABC Corporation stock. You still own 10 shares of it. But ABC Corporation, due in no small part to your very generous investment, has appreciated in value, and the shares are now worth $15 a pop. So how much is your ABC Corporation stock worth? $150. And let's say 1 year from today, that's the end of the road, at least on Earth for you, and your estate takes over the ownership of the ABC Corporation stock. The ABC Corporation stock is worth $150. Let's say the only beneficiary in your estate is your son. Let's say that he's your only named beneficiary. Your son is going to take $150 worth of ABC Corporation stock. If your son goes and sells that ABC Corporation stock, how much tax is he going to have to pay on the sale of the ABC Corporation stock? It's called a stepped-up basis. If you give something to somebody through your will, or if it's something you owned at the date of your death and you pass it on to somebody else, the tax basis that the person who's taking the asset receives is the fair market value of the asset on the date that the giver died. So in this case, it's $150. If instead you gave it to our hypothetical decedent, if instead gave it to the son 1 day before, let's say it's April 12th, 2025, ABC Corporation, still 10 shares of it, it's still worth $15, and you give it worth $150. Jim, do you want to take this one? How much tax is he going to have to pay? Okay, let's assume that there's no provision there. What the tax basis that the son is going to take is $100. Because he's going to take the same basis that the original purchaser had. So now he's on the hook to pay Uncle Sam $50.
Well, the tax would be on the $50.
Exactly. So you can give away everything before you die, but you're going to end up sticking somebody with a tax bill somewhere along the line, assuming the numbers are big enough. You're going to end up sticking somebody with a tax bill. We also don't like people to give away assets before their death because it can put them into a situation where they're destitute and relying on people to take care of them when they could have looked out for themselves ahead of time. So that's one thing to consider. So when you've made your decisions about what you want to have happen, you can go ahead and opt to do a will. And a will, there are several requirements to make a will. Here in Iowa, the will has to be a signed writing. It can be in your own handwriting, that's fine, but you have to have 2 witnesses for the will. The witnesses have to be there in your presence when you sign the will. I don't think over Zoom works. They have to be in there in the room with you when you sign. They have to know who you are. They can verify that it's you. You have to adopt the document, say this is mine. This is what I want to have happen. This is my will. If you want to make changes to your will, the changes have to be executed with the same formality as the original document. Another real life example, already in my practice, in private practice, I've seen an example of a guy who had his will. He had one son at the time. He had another son after he executed his will. He took the will, he wrote in the margins, and Tommy. And Tommy. Every time he mentioned his first son, and Tommy, and Tommy. And he initialed every time he wrote and Tommy. So we knew it was him. Doesn't count. It wasn't witnessed. Didn't meet the formality requirements. Now, fortunately, there are some protections in the probate code in Iowa law to look out for people who aren't provided for in wills. One of those is that of an afterborn child. An afterborn child who isn't provided for in a will gets the same share as what a child would have gotten, an equal share of what the children would have gotten under the will already. Also for a spouse who is not provided, you can't disinherit your spouse. You can't do that. A spouse will at least take 1/3, essentially, of your assets if you don't provide for your spouse in your will, whether due to mistake or due to other motives. But you can't do that. Again, you don't necessarily need to do a will. Iowa has the probate code. It's 145 pages long. The state has decided what should happen with your property after you die. It isn't necessarily the bad thing or a bad thing. Basically, all of it's your heirs who would get your property, and most people are perfectly content to have their heirs take their property. By the way, Bill, who are your heirs?
Well, my first year would be my wife.
Incorrect. Yeah, right. Martin, who are your heirs? Incorrect. Let's see. Who else can I pick on? No, not you. Bob, who are your heirs? So, you would have thought. Okay, why would you have thought that? No, well, they're not. The reason they're not is because your heirs are determined on the date of your death. You don't have any heirs right now. That's another one of the problems if you don't have a plan in place before you die. You don't know who's going to get your stuff because you don't know who's going to be left. So this is another thing that you can take care of ahead of time. You can draft a will and you can say who's getting what and you know who's going to end up with what. Yeah.
How much of your property has to be in state, or how does that, let me just go back to that example, the situation with my sister. She was very easy to work with and all that, but we had a funny thing because she looked at my mom's gold-plated tableware and she said to us, to my brother and me, I get that.
Mm-hmm.
And we weren't gonna fight with my sister,
Mm-hmm.
but that was just, and we have no idea what the value is, nobody checked it out, we just said, okay, Maureen, you take it.
Mm-hmm.
You take it.
Right.
But should that technically have been evaluated and all that kind of stuff? How does that work?
Yeah, I mean, so the executor in a will is going to be appointed to take care of everything that's provided for in the will, make sure it goes where it's supposed to go. She was? Yeah, right. So, yeah. So this is another thing to consider when you're appointing an executor under a will, when you're appointing a trustee for a trust, you need to trust that person. You need to verify their character. You need to, ideally, you would know that they're in a good financial situation themselves, so they would not be tempted to misuse the things that they're entrusted with. Now, practically speaking, a lot of times that sort of thing does happen, and it's not worth fighting about. So what's supposed to happen and what actually happens don't always line up, and a lot of the time it doesn't cause a problem. If it does, then you have brother and sister in court fighting about $75,000. Sometimes that happens. And oral agreements and like agreements that you have before somebody dies, those are rarely honored because people will say, well, grandma's gone now, so I can take what I want, and yeah. So just another reason to have things in writing and to have things provided for specifically in writing. And those are things that you need to decide ahead of time. Yeah.
So, question, if you don't have a will, and all the children come in and take what they want beforehand, before a lawyer's involved, what happens there? Do they just walk over?
Well, then you can go into litigation. I mean, you would still, yeah, there can be fights for sure. And that's another reason to have a will or have a plan in place rather than have it be, well, now we need to scramble, we need to play catch up essentially and figure out who's going to go and do what. Who's even going to be an executor? Go ahead. I mean, so after that happens, you have to appoint an executor, and it's an adversarial process to decide. Technically, there's a difference in terminology. You'd be an administrator because there's no will in place, but if there's no provision in a will for an executor who's going to be in charge of making sure everything goes where it's supposed to go, it's fighting it out to decide who's going to do that. basically. If you can't reach an agreement, yeah. Now, if you have an agreement, you can go to the court and say, hey, we want Joe Bob to do it. Okay, great. Court's going to say Joe Bob. Court doesn't have to worry about it. But yeah, if there's a fight, yeah, you have to fight it out. When you're deciding what you're going to put in your will, you can put just about anything you want in there. Almost anything. Not anything, but almost anything. You can give gifts to charities. You can give gifts to people. You can give gifts to your church. You can put conditions on those gifts. One of the classic law school exam questions is, can I give money to my cousin Susie if she graduates from law school? Well, yeah, you can. You can make her go to law school to get some money. I don't know why you would do that, but some people, at least in the law school textbooks, like to do that. But that's up to you. If there's a certain thing that you want to have happen, if you want somebody to go to medical school, you can provide a gift that if you graduate from medical school, you'll get X number of dollars, maybe pay off some debt. That's something that you can do. Yeah. So it would be probably in like an escrow account kind of thing. It would be sitting there. You would have the executor would still be in charge of it, and you would have the executor gets to collect fees. So it's not like it's a total burden, but you have to wait around and see. And that's why there are fancy things like the rule against perpetuities, which I will not explain because it's too complicated. But it protects situations like that where we get too remote in time from when the gift was given, and we can't give it out. Basically, we can't find the person to give it back. There are some challenges when you want to make a will. I should mention the functions of having a will. So, yeah. Yes. The question was, what would happen a few years down the road if you have a gift that's subject to a condition, such as going to medical school? What do we do with the money in the meantime? The functions of a will, it will clear title, it will also prove title. A clear title is one that does not have any encumbrances, any claims of creditors or liens on it. The will and the other assets provided for in the will clear the title before it passes to somebody. And in the case of a big asset like a house, how do I know I have the house? Well, here's the will giving it to me. You can prove your title to the house that way. So it gives you a paper trail for your beneficiary to prove that they have what they actually have. There are some challenges that people can bring to wills. The big one is incapacity. You have to have, another requirement of making a will, you have to have adequate capacity to make the will. The rules for having capacity to make the will, you have to know the nature of the instrument that you're executing. You have to know that the document that you're signing is a will, and what a will does. You have to know and understand the nature and extent of your bounty. All your property. You have to know what you have. To a reasonable degree of certainty. If Bill Gates doesn't know where every last dollar of his that he got from Microsoft, if he doesn't know where every last dollar is, he doesn't lack capacity to make a will. If he knows to a reasonable degree of certainty, he can make a will. You have to know the natural objects of your bounty. You have now, as opposed to heirs, okay? People I picked on for heirs, you have natural objects of your bounty, people who would stand to benefit from your property if and you go away. You have to know who would stand to get things through natural succession. And you have to know the distribution you desire to make. This is a low bar. The bottom line is, it's a very low bar to have capacity to make a will. There are some famous examples of this. There was a guy in Iowa, lived on a large piece of property, had many trees on it. He was convinced that a race of tree people had moved into his trees, and they were living in the trees, and they were escaping his notice. And he was really mad about the tree people living in his trees. And he had decided that he would leave some money in his will to go get the tree people out of his trees. So he dies, they open up his will, and they find however many thousands of dollars left to get the people out of his trees. And his kids look at this, and they go, what's Dad doing? There are no people living in his trees. Why is he giving money to get the people out of his trees? And they challenged the will. They said there's no way that Dad should have made this will. He obviously lacks capacity to make a will. There are no people living in his trees. We should get the money that he left to get rid of the people living in his trees. Guess what? The tree people won. The tree people won. The money went to get rid of the tree people. The kids didn't get it. Okay? So it's a very low bar to have capacity to make a will. You can operate under factual mistakes, factual delusions, and that won't affect the validity of the will. Yeah. Great question. That wasn't part of the court opinion. Okay. You can also have undue influence. Undue influence and confidential relationship. This is where there's a very close relationship between somebody who stands to benefit from the will and the person making the will. If there's a situation where somebody is in decline and somebody else is managing their checkbook and paying all the bills and paying themselves some gifts along the way, that's where you can start getting into some challenges where, oh, I don't think it was Dad who made that gift. I think it was Brother Bob who made that gift. You can have challenges that way as well. How do you combat that? You act sooner rather than later. Don't wait for decline to come into the picture. Get on the ball, do what you need to do now, and don't worry about it later. Trusts. We're going to talk about trusts briefly. A trust is a situation where the burdens and benefits of property are separated from one another. What that means is somebody gets to enjoy the fruits of the property while somebody else deals with the headaches of managing the property. Classic example would be like a stock portfolio or something like that. Somebody gets to enjoy the income, the dividends from the stock. Somebody else has to worry about investing it. Another example would be a rental property. Somebody gets to enjoy the rents coming in from the rental property. They get to spend them how they please. Somebody else has to deal with managing the rental property. With trusts, like I mentioned with executors, you have to choose a trustee. The trustee is the one who's responsible for managing the property. The trustee needs to be someone who is trustworthy, someone you can trust. The trustee has to act for the benefit of the trust and all beneficiaries. So the trustee cannot do something just because the settlor tells them to. The trustee has to act in the best interests of the beneficiaries. Yeah.
So in your experience, have you seen better results with people using someone they trust, like family member, but they may have some kind of interest, right? Or going to some sort of supposedly neutral party for a trust, like say a bank or something like that, a bank trust. Have you seen any difference in the results?
So the question is it better to use somebody who's personally interested, personally related, who knows you, you know them, or is it better to go to a professional like a bank? And the answer is yes. It depends on what the assets the trustee is supposed to manage are. If you've got something that's simple, there's no reason to believe that a layman couldn't do it. If it's a large portfolio, you might want a professional to do that. Obviously, a trustee is entitled to compensation for dealing with these burdens of owning this property and managing this property, but that can be provided for in the trust, and it's capped by law, so you don't have to worry about somebody taking you for working on your trust. It's going to be pretty situation specific for what you want to have happen. You can have testamentary trusts. Hey, there we go. You can have testamentary trusts. You can also have what we call inter vivos trusts. A testamentary trust is a trust that is created in somebody's will. A testamentary trust cannot be undone. Why can't it be undone? Because you're already gone. The type of testamentary trust you can set up is based on the purpose that the testamentary trust is supposed to accomplish. So what you can do is you can set up a trust for your spouse, to provide for your spouse while they're still living. That's called a marital trust. You can provide a trust that will provide for your kids. That's called a maintenance trust. You can provide for a special needs trust if you have somebody who has special educational needs, that sort of thing. Somebody's favorite would be a credit shelter trust. You can shelter assets from your creditors. You can shelter it from Uncle Sam to a certain extent. The disadvantage with doing a credit shelter trust is you don't get the stepped up basis that we talked about before. So the question that you have to answer is, do I want my estate to be liable to pay taxes, or do I want my beneficiaries to be liable to pay taxes? That's something that you have to decide. And that's also a common theme of estate planning. It's not so much whether you'll pay tax as to when and who will pay tax. You can also set up trusts to care for your pets. Some famous examples: Michael Jackson had a pet chimp named Bubbles. Michael Jackson set aside $2 million to take care of his chimp Bubbles. Bubbles now lives in a wildlife refuge. I'm sure the rest of the chimps in the wildlife refuge are very jealous of Bubbles' $2 million. You can also make inter vivos trusts. This is a trust that you make while you're still living. Inter vivos is Latin for among living people. Inter vivos trusts come in two main types. You can have a revocable trust or an irrevocable trust. A revocable trust can be undone. An irrevocable trust cannot be undone. Why might you choose one or the other? Well, revocable trust, you can do it over. Great. If things change, you can go back to the drawing board and start over. Drawback, it's very costly to set up. You have to transfer all of your assets into the revocable trust. You have to retitle them as being in the trust. You also have to execute what's called a pour-over will. This is to answer the question that Bob raised earlier during his presentation. If you acquire something that isn't provided for in your will, a pour-over will in the situation of a trust, if you didn't have time to transfer ownership of that asset into your revocable trust, that asset would be disposed of in your pour-over will. So it can be a little bit of a cumbersome situation if you want to deal with a revocable trust. An irrevocable trust, the feature is you can't undo it. It's permanent. There's no going back on it once you've made up your mind. The advantage of this is that you no longer own your assets. And that has advantages for you for Medicaid purposes. If you don't own your assets, they have no value to you. It makes you look poorer, essentially, than you actually are. You would still get the benefits of things that are in an irrevocable trust, but you can qualify for Medicaid, and you can have some extra income to pay for nursing home expenses and that sort of thing. So there are some different things that you might want to consider, whether you would want a revocable trust or irrevocable trust. You can also do what's called a discretionary trust, where the trustee has complete discretion over how much money to pay out to you to sustain you, and the trustee is bound by fiduciary duties to you to make sure that the trustee is giving you enough money to live on. But that takes all of the worry and responsibility off of you entirely. You can also do a spendthrift trust. Spendthrift provision means that a beneficiary of a trust cannot sell their interest in a trust. Ordinarily, the beneficiary of a trust could sell their interest in receiving the benefits of a trust for money to somebody who wants to be the beneficiary of the trust. A spendthrift trust prevents that. The advantage of that is the beneficiary does not have to worry about creditors coming and attaching their interest in the trust. That's an asset that can't be touched by a credit card company or somebody like that. So, wow, time is flying. So planning for incapacity. There are two things that you need to consider when you're planning for incapacity, and that is what's going to happen to you and what's going to happen to your things. Setting up a power of attorney allows somebody who is designated by you to manage your things or manage your person. Either to make healthcare decisions for you, maybe where you're going to live, and also to invest and manage your assets. It's always best to have this set up well ahead of time before you need it, because if you lack capacity, like we were talking about earlier, and you don't have this plan in place, like we were talking about with Jim, if there's no executor in place, or if there's nobody designated ahead of the time that you lose capacity, you have to go to court. And it's an adversarial process to decide who's going to manage you and who's going to manage your things. And that is not a situation that many people want to find themselves in. So if you want to arrange for a power of attorney, you have to identify the person you want to serve as your agent. The agent makes decisions for you when you can no longer make them yourself. You can decide whether you want a power of attorney to be immediate. You can give somebody power to make decisions on your behalf immediately. Obviously, that can create some problems if your agent has some different ideas than you have. Or you can arrange it to be springing, and the agent can receive authority to make decisions on your behalf after a certain condition has happened, after you lose capacity. Now, that's probably what most people would opt for, but it's difficult to administer because you have to get a doctor to sign off and say, hey, this person's incapacitated. Then you have to go take it to the agent, and the agent has to start making decisions. That can take some time. So the big thing, if you're arranging for a power of attorney, you need to know who's going to be your agent. You need to trust that agent. You need to know that that agent is going to make decisions that you agree with. You know that agent's going to act in your best interests. You need to put your life and your possessions in their hands. And that's something you need to decide for yourself. Nobody can tell you that, oh, you should pick Susie, you should pick Bobby. No, that's your decision to make. This is a pet project of mine. I want to make sure that everybody understands that when you sell a house, you need to disclose everything about the house. I had a fellow who built a house in 1962. He was the only person who lived in that house from 1962 to 2021. He built the house, lived in it all those years. It was a nice place, kept good care of it. Was it 62? I think it was 62, yeah. Kept good care of it. And he went to sell it to a young couple who wanted to move in. He sold it to them. He went through the property disclosure forms, filled out everything he thought that he needed to fill out, and sold them the house. The new couple moved in, and they went down to the basement, tore down the finished walls in the basement to do some renovations, and they discovered a crack in the foundation. The crack in the foundation had been there since he built the house. Apparently it had been a very cold winter when he built the house, and there was this crack that appeared in the foundation. He patched it up, and he didn't think any more about it after 1962. Problem was, he didn't put it on this form, and this is just items 4 through 12 of your property disclosure form. This form is 3 pages long. I think there are 30 to 40 items you need to fill out. But he did not say that there were any known foundation issues. Do you know what the buyers said to him? You've got to pay us to fix up the foundation of the house because you didn't tell us about it. And if you had told us about it, we would have known that we had to fix the foundation, and we would have paid you less money for the house. Well, this guy is 95 years old at this point. He's living in a nursing home, and he was on the hook to pay several $1,000s to this new couple to fix up the house. So, bottom line, disclose every last condition that you know about in your house. Keep a list. You have somebody in to do work, put it on the list. You notice a leak on that window in the basement, write it down. Keep track of everything. Lastly, we'll skip that. I do want to cover this real quick. I mentioned that the law, what we're dealing with today, for the most part, perfectly just. There are some people who want it to be not that way. There was a bill introduced in the Iowa legislature this past term that would give Iowans the right to medically assisted suicide. That's currently illegal. Physicians cannot help people commit suicide. People cannot commit suicide with medical assistance. That is illegal. But there are some folks in the legislature who decided it would be a really good idea if we would let doctors help out their patients who have a terminal illness in ending their life. Now, this is wrong. Was it you? Who said it? That the day of death is better than the day of birth. And that's true, but it's not our decision when the day of death comes. That's not in our hands to decide. You can let people know that you don't like laws that are being passed. This is a big one for seniors, obviously, for folks who are diagnosed with a terminal illness. Terminal illnesses are more commonly diagnosed in aging populations. you can do something about it. You can contact your legislators, and here in Iowa, our state representatives represent about 30,000 people, so it's reasonable to get a hold of them and actually have a meeting with them face to face. And I would highly recommend that you go and meet with them face to face if you want to have your mind made known about how you think about this bill or any other bill. Don't do it by phone. Don't do it by email. I mentioned that I interned for Senator Grassley. When I was interning for Senator Grassley, I fielded calls from people who wanted to rant and rave about their theories that they had. One of them was that John F. Kennedy was still alive and that he and President Obama had stolen the Heisman Trophy and had hidden it in Hawaii. I don't make this stuff up. I don't make this stuff up. But that's the sort of thing that people who are working in government offices have to deal with all the time. When it's over the phone, when it's by email. But if you can go and you can get somebody face to face, you can let your opinion be known, and that'll have a lot greater effect than just sending an angry email. Questions? Yeah? No, it did not. The bill was introduced, it died in subcommittee. Good, right. But you can see what would happen and the type of legislation that would be brought to the floor and would be voted on and would be passed if we had different representatives or the representatives were listening to different people. Yeah. Sure, yeah. Call's better than nothing, but I know, like for Senator Grassley, he likes to have brunch every Sunday at Village Inn in Cedar Falls. So, people are creatures of habits, and you can find where they are. If you want to go have a conversation with them face to face.
My sister's a pharmacist in Oregon. They have an assisted suicide law.
Right.
And they don't have an opt-out for professional conscience.
Right.
Have to, if she was going to keep her pharmacy license,
Right.
prescribe those medications for children.
Right. Yeah. Oh, for sure. Right, yeah, the point was that this affects more than just the elderly, and that's absolutely true. The variation that's in effect in Canada applies to mental illness. If somebody is diagnosed with major depressive disorder, they would be a candidate for medical suicide. It can be some really pernicious things. Did you have something?
Is that legal in California?
I don't know about California's law. Yeah. Mm-hmm.
So that is just something else to keep in mind while you're entering the state.
Yep, and that is why a lot of people like to opt for those trusts that will keep beneficiaries protected from claims of creditors, that being one of them, although oftentimes the state can get in regardless of those protections, because Uncle Sam's going to get paid regardless.
Yeah, this whole power of attorney thing can get really tricky though, because my wife has no siblings, and her mom was in Kansas. Her mom's doctor, my wife had power of attorney if my mother-in-law was incapacitated. She was beginning to show some signs of dementia, but not too much. Had somebody helping her. She was still driving though. Her doctor said to Jenny, "You need to take her keys away." She had a minor fender bender. She called the state of Kansas, and they said, "No, we can't do that. She passes the test." My mother-in-law would go to the thing, and they would feed her the answers, so she would pass the test. So here you had this back and forth. How do you put the power of attorney? All of us could be in situations like that someday.
Right. Yep. All right. I think our time is up. If you guys have more questions, I'll be around. Obviously, there's many more hours that we could spend talking about these things. So thanks for listening.